Hello, my name is Barry O'Connor. I'm an attorney licensed to practice in the state of California and also licensed in the federal court. I'm also a landlord, and I've been doing landlord-tenant law for over 25 years. What I wish to speak about today is 3-day notices. A 3-day notice is the first step in an eviction proceeding. If a tenant has not paid their rent or a landlord has not received the rent, legally a 3-day notice may be served on the tenant. A 3-day notice must have rent only on a residential property. It cannot have late charges or other fees. A 3-day notice also must state where the 3-day notice is to be paid to, who it's to be paid to, the hours it's supposed to be paid, should be a phone number on it, should be a name on it, and also should state if the tenant lives more than 25 miles, the tenants are entitled to mail the rent to the landlord. A 3-day notice also may be required to be deposited into a bank account if that's the procedure that was done through the entire term of the tenancy. Service of the 3-day notice may be accomplished in several ways. The best way is that if a tenant is served personally with a 3-day notice. Another way to serve the 3-day notice is to knock on the door and somebody answers, so not the tenant. If they're a responsible adult over the age of 18, they may be served the 3-day notice. Then a copy must be mailed to the tenant's address. Also, if you knock on the door and nobody answers, a 3-day notice may be taped to the door in a conspicuous place where it's very visible when you walk up to the house, and secured on that door, and a copy must be mailed again to the tenant's address. It's very important that the 3-day notice, the tenant pays the rent within that 3 days. If they don't pay the rent in the 3 days, then the landlord has the right to file an unlawful detainer action. If the 3rd day ends on a Sunday or a holiday, a tenant has an additional day to pay the rent.